Welcome to Crime in Court. My name is Heather, and this is an update in the Delphi case. So, this is Indiana versus Richard Allen in the pursuit of justice for Abby and Libby. So, in our latest video, it was a little while ago, we read through this recipe for determination, and that was from the defense. So, they were asking for the Supreme Court to apply this trial rule for 53-1. It's also called the lazy judge rule, basically stating that Judge Gull has taken too long to respond to our motions. She's ignoring us, and we want her kicked off the case for this reason. I thought their motion was well written, clear to read. We went through it. They even come down here and lay out how many days it's been since she's ruled on things. So it was 119 days since the defense filed its third Frank's motion. They haven't heard a response. 72 days since they filed the fourth Frank's notice. It's been 64 days since the court claimed that it would be ruling on the third and fourth Frank's, and they still, to this day, have not had an answer. They filed for recusal. Okay. So, I mean, it's clear as day she's not responding. She should be responding within 30 days on all motions by both parties. Hold on one second. Sorry about that. All right. So they list out all the days and how she's clearly been late. Like I said, 30 days is the requirement. All right. So this is the Indiana Supreme Court's ruling based on their motion, their recipe for determination. So here it is, and they filed it the 19th of July. All right, so notice of Chief Administrative Officer's determination pursuant to Trial Rule 53.1E. Chief Administrative Officer of the Indiana Supreme Court pursuant to Indiana Trial Rule 53.1 finds that withdrawal of the submission of the above matter from the judge is not warranted. I'm like, are you freaking kidding me? When I first saw this, it made me so mad. I didn't even want to do a video on it because I'm like, what? I didn't even want to read through it. So I'm reading through this all for the first time with you guys. I'm already mad because I knew the outcome, so I don't even know how I'm going to feel going forward. All right, so a review of the chronological case summary reveals that on March 13th, 2024, Mr. Richard Allen filed a motion entitled Richard Allen's Third Frank's Notice and Request for Frank's Hearing based upon newly discovered evidence and request for findings of fact and conclusions of law upon any ruling on this request, because she wasn't giving them her reasons. She was just denying everything without hearing. On April 29th, 2024, the CCS reveals that Mr. Allen filed a motion entitled Defendant Richard Allen's Fourth Frank's Motion, based upon newly discovered evidence and request for hearing. On May 7th, 2024, the trial court issued an order or judgment of the court wherein the trial judge stated defendant's third and fourth request for Frank's hearing will be ruled upon and not set for hearing unless necessary. On July 11th, 2024, Mr. Allen filed his recipe seeking to have the matter withdrawn from the trial judge for failing to rule on his two motions pursuant to Trial Rule 53.1A. However, Mr. Allen is mistaken and the matter should not be removed from the trial court. What? What's the mistake? Why is it so difficult for defendants to get their rights met in court proceedings? It's really difficult. Like, they really get their rights trampled on. As I'm following these cases and reading through court documents, that's what I'm seeing is the court and the government using all their power against one person and their attorneys. Ridiculous. All right, so according to Trial Rule 53(1)(a), if a trial judge fails to rule on a motion or set the motion for a hearing within 30 days, the cause may be withdrawn from the trial court. However, Mr. Allen has waived any relief under Trial Rule 53.1 by filing motions beyond the time that either party could have legitimately raised a claim for removal. What? Filing motions beyond the time that either party could have legitimately raised a claim. Why? How do you figure? Regarding the predecessor rule to Trial Rule 53.1, the Supreme Court held, quote, "It is well settled that a party cannot claim the benefit of Rule 1 through 13 when by his conduct he has consented or waived his right to claim it." When did he waive his right to claim it? What are you talking about? Board of Medical Registration and Examination versus Turner. The case was cited for the holding in state whatever cop versus or copy versus Cass Circuit Court. In footnote 1, the Supreme Court stated similarly, the benefit of trial rules 53.1 or 53.2 may be waived where the deadline for a ruling has passed, but rather that filing a precipice to withdraw the cause, a party files pleadings or otherwise takes voluntary action of record inconsistent with the party's right to invoke those rules. I'm so confused. What does that mean? Benefit of those rules may be waived when the deadline has passed, but rather than filing a precipice to withdraw the cause, a party files pleadings or otherwise takes voluntary action of record inconsistent. I don't know what that last part means. All right, so if anybody in the comments knows and would like to explain it, especially lawyers, that would be great. All right, so Mr. Allen filed a motion on March 13th, 2024, which warranted the trial court to issue a ruling on the motion from April 12th. The trial judge failed to issue a ruling by April 12th. However, instead of filing a precipice for withdrawal as early as Monday, April 15th, or prior to the filing of any subsequent motion, Mr. Allen filed an additional motion. So, how does that waive his right to this? I don't understand that. That makes no sense. This is stupid. On April 29th, 2024, Mr. Allen filed his defendant's Richard Allen fourth Frank's motion based upon newly discovered evidence and request for hearing, but it was like a separate motion. It was separate evidence. So why they both were on separate topics. I know the fourth Frank's motion was on the geofence data, whereas the third Frank's motion I think was on the inconsistent things said by law enforcement and about Elvis Fields and the other individuals involved, Holden, and I can't remember all the names now, but you know who I mean. All the shady characters. In terms of Mr. Allen's motion filed on April 29th, 2024, he has also waived any relief under TR 53(1)(a). Mr. Allen's motion warranted a ruling by the trial judge by Wednesday, May 29th. The trial judge failed to issue a ruling by May 29th. However, instead of filing a precipice for withdrawal as early as Thursday, May 30th, or prior to the filing of any subsequent motion, Mr. Allen filed an additional motion. So because he files another motion, he waived his right to get any relief. That makes absolutely no sense. This is now multiple instances of her not ruling in time, and yet the Supreme Court's way to deal with it is denied because you continued to fight for your rights as a defendant. You didn't sit there and wait or file a precipice immediately. I just don't get this. I don't get this rule. So on June 18th, 2024, the CCS reveals that Mr. Allen filed a motion entitled Accused's Response to this Court's May 31st, 2024 Order or Judgment of the Court and Notice of Conflict. Because Mr. Allen filed a motion seeking to advance the matter before the trial court, Mr. Allen has waived any relief under TR 53.1A concerning his motion filed on April 29th. This is BS. The precipice is denied. Accordingly, submission of this case is not withdrawn from the trial judge. In accordance with Indiana Trial Rules 53.2E and 53.1E, the local clerk must enter this determination in the chronological case summary of the case and provide a copy of this notice to the trial judge and all parties of record in the proceeding. Done at Indianapolis, Indiana on 7/19, signed Justice P. Faulkner. And Justice P. Faulkner, I think your ruling sucks. And I think you made a huge mistake. She needs to come off of this case. She needs to come off the bench permanently. She has shown her bias, her and all of her prejudice and animosity towards Richard Allen and his defense team. And the fact that she's not ruling on their motions in a timely fashion should prove to you, repeatedly, she has not done so. So that should prove to you that she is not taking this case seriously, or she's undermining justice by not ruling on their motions. And just because they file another motion, which is separate and different from that motion, doesn't mean that he should lose his right to this relief. That makes absolutely no sense. It's like, so you could get your judge removed from one instance of not ruling in time, but if you file something after that, then you can't. It makes absolutely no sense, Supreme Court. So this makes me angry. What do you guys think? Let me know in the comments below. I've been saying since long before that she needs to come off this case. She should come off the bench. Period. End of story. I don't think she should be allowed to be a judge anymore. Some of these judges get so much power and it goes to their heads. They become so corrupt, like Judge Cannoni, I'm talking to you, and Judge Gull, talking to you. I'm really sick and tired of seeing just the government just trample over people and their rights. I think this is wrong. I think this was a definitely a wrong ruling, and even if he did waive his rights, as a Supreme Court justice, you should be able to say, well, she's done this repeatedly. I should make a wise decision instead of just throwing it back down to the circuit court. So stupid. Anyways, that's my thoughts. Let me know in the comments below what you think. Please hit the like button on your way out, and I appreciate it. Thanks so much, guys. Take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.